the Chairman, BIAC Board, Mr. Mahbubur Rahman, esteemed members of the BIAC Board, my esteemed peer judges and former colleagues, Supreme Court of Bangladesh, a highly respected veteran judge, Mr. Justice Aulad Ali, the Supreme Court of Bangladesh, Madam Justice Fatima Anwar, Barrister Samir Sattar and his distinguished panel of speakers, Excellencies, honored guests, ladies and gentlemen, a very good afternoon to you all. It is a profound honor to address this seminar this afternoon. I'm mindful that our deliberations today on advancing justice and business confidence through ADR occur at a juncture where the boundaries of law are expanding in unprecedented ways. Poignantly, our discussions today coincide with the second anniversary of the July-August 2024 student-led revolution. The martyrdom of the brave souls during this revolution resulted not merely in a political shift, it rekindled our moral imagination and hardened a collective resolve to restore equity, reminding us of the moral architecture of the rule of law. At the foundation of our legal order lies the profound philosophy of John Locke, who posited that human society is bound by a fundamental social contract, a sacred covenant wherein individuals surrender certain natural liberties to the state, not to submit to arbitrary authority, but to secure their inherent rights to life, liberty, and property. Locke rightly asserted that governmental power is not an inherent privilege, but a public trust held on the strict condition that it serves the common good. Drawing on my work as the 25th Chief Justice of Bangladesh, I hasten to add that institutional growth and efficiency are indispensable to secure such common good. I have always maintained that the quality of a nation's judiciary is a primary economic indicator. By prioritizing speedy, efficient, and transparent adjudication, we are constructing a robust architecture for commercial justice. In the globalized economy of the 21st century, investors, both foreign and domestic, do not judge a country solely by tax incentives or infrastructure. They seek certainty. They seek assurance that contracts will be honored, rights will be protected, and disputes will be resolved, not over decades, but within months. We must confront the reality that, for too long, enforcing a commercial contract in Bangladesh has been a deterrent to foreign investment and a brake on domestic entrepreneurship. We must recognize that the adjudicatory framework we are building serves as a genuine lifeline of our national economy. Contemporary legal scholarship and institutional economics universally acknowledge the symbiotic relationship between an efficient justice delivery system and economic performance. To meet this challenge, my own judicial reform roadmap, declared on 21st of September 2024, emphasized procedural efficiency as a core pillar of institutional reform. We must move towards a new judicial philosophy for commercial disputes, one that recognizes time as a critical element of justice and treats procedural discipline as a constitutional duty. In this context, I shall like to dwell on certain aspects of the legal regime on arbitration as chiefly governed by the Arbitration Act 2001. The courts have been struggling for years now on the territorial scope of application of that particular act, trying with varied and often discordant results on internationality of the act's outreach, especially when interim measures are being sought to be imposed. Taking Section 3 of the Act as the legislative bedrock of the principle that the Arbitration Act applies only if the place of arbitration is in the territory of the enacting state, the time has come now to adopt a broader notion of internationality as incorporated into the amending provisions of the ancestral model law of 7 July 2006. The notion of international commercial arbitration, at least since 2006, benefits from a very wide interpretation given not only to all relationships of a commercial nature, whether contractual or not, but also from a broadened concept of internationality, intended to encompass cases where the place of arbitration, the place of contract performance, or the place of the subject matter of arbitration agreement relate to more than one country. This inevitably impacts too upon the territorial scope of application of any enacted law, like the 2001 Act. The model law of 2006 mandates, therefore, the application of certain articles incorporated in the model law, regardless of whether the place of arbitration is in the enacting state or not. This enhanced idea of territoriality, for our purposes, is best exemplified in Article 17J of the model law, which provides that a court shall have the same power of issuing an interim measure in relation to arbitration proceedings, irrespective of whether their place is in the territory of the enacting state, as it has in relation to proceedings in courts. This notable innovation potentially resolves the conundrum stemming in this very jurisdiction on the territorial scope of arbitration from discordant rulings on interim measures in two cases. That is, the HRC Shipping Limited case and the STX Corporation Limited case. By way of a footnote, and I wish he was here, but he's not, and I'm referring to Justice Shamim Hussain, who's a member of the Law Commission. He was invited, but he's regrettably unwell today. And this is why I sort of, I referred to him. Of the two cases I just mentioned, it is the HRC Shipping limited case that benefited from an expansive and purposive interpretation of the existing law. And it was Justice Mr. Shamim Hasnan who was the author judge in the HRC shipping case, and in spite of the limitations of Section 3 of the Arbitration Act, he gave a green signal to impose to issue interim measures in a case where the place of arbitration was not Bangladesh, but it was abroad. So it was a very visionary judgment, and it sort of aligns completely with the ethos and the philosophy of what is now suggested and incorporated in the model of 2006. I addressed, in Mr. Justice Shamim Hasnan's absence, I addressed this proposal to the esteemed chair of the Law Commission of Bangladesh, my former colleague and peer judge, Madam Justice Zinatara, and of course, my dear friend from my student days at Dhaka University, and also an esteemed member of the Law Commission, Dr. Naima Haq. And now for a matter I feel very strongly about. This has to do with the autonomy of the arbitration process itself. And this autonomy stems from the autonomy of choice of free will of parties to proceed to arbitration in the first place. Such autonomy, however, risks being substantially curtailed through any inimical legislative provision allowing for extensively intrusive judicial oversight and interference. This therefore takes us to the necessity for a clear delimitation of the model law of 2006 terms as court assistance and supervision, called in aid of a given arbitration process. This assigns, therefore, a potentially benign role to the judiciary operating under limited and clearly defined terms in the realm of international commercial arbitration. The underlying idea is that the judiciary's supervisory role is that of an aid, only an aid to arbitration, which shall not dislodge in any way the primary intent and objectives of the arbitrating parties. This in turn respects and entrenches the primary intent of the parties to deliberately avoid court jurisdiction in favor of what the Uncitral Secretariat terms as the finality and expediency of the arbitral process. Areas of intervention are accordingly found delimited in the model law itself to be entrusted to courts in a manner quite similar to what we now see in the Arbitration Act 2001 itself. But there is detected yet a broader objective behind such statutory responsibility given to courts that aims at the capacity building of the courts themselves and other aligned institutions like BIAC and even chambers of commerce. As commentary from the Uncitral Secretariat suggests, court jurisdiction over issues of appointment of arbitrators, challenge and termination of an arbitrator's mandate, an arbitral tribunal's jurisdiction, and the setting aside of arbitral awards are intended to further a broader purpose, and that is the centralization, specialization, and efficiency of specially designated courts. The bottom line, therefore, for any legislative scheme is to protect the arbitral process from unpredictable or disruptive court interference, particularly where foreign parties are involved. True reform, ladies and gentlemen, requires in this regard moving beyond generic courts towards deliberate specialization. Speaking of specialized courts, I must broach the issue of the genesis of the dedicated commercial courts in this jurisdiction. It was in Chattogram in January 2025 that the first earnest call was received by me as Chief Justice from the country's entrepreneurs and business community to set up a dedicated commercial court system that could match the pace and sophistication of Bangladesh's expanding economy. Fresh from my Abhibhashan of 21st September 2024, declaring my judicial reform roadmap, this call for setting up commercial courts appealed to me as an effective model for decentralizing justice delivery in a highly specialized area of the law. Indeed, in the domain of territorial distributive justice, the argument for emplacement of commercial courts all over the country, especially in key commercial centers, has always been overwhelmingly convincing. It cannot be gainsaid too, ladies and gentlemen, that institutional capacity building for or empowerment, Bangla যেটাকে আমরা বলি ক্ষমতায়ন, is an essential component of and a prerequisite for any meaningful process at decentralization or বিকেন্দ্রীকরণ. And all this came together in the architecture, the ethos, the philosophy of what we now call the Commercial Courts Act, which was born, I've heard that word being used so effectively today, ecosystem. If you go back to 2025, we were operating under a different ecosystem, which spawned legislation concerning the Supreme Court Secretariat, and setting up for the first time in this nation's history a Supreme Court judges appointment collegium. So that was the essential ecosystem against which the commercial court ordinance, the demand, gained momentum. And of course, it is the last ordinance that has now survived. And we have to be thankful for that at least. At the heels of the January 2025 Chattogram Reform Roadshow on judicial independence and efficiency, a dedicated research team at the Supreme Court prepared the initial draft of the legislation. The draft underwent rigorous scrutiny through nationwide roadshows, detailed consultation with the Bangladesh Investment Development Authority, or BIDA, and expert reviews by commercial law specialists and business stakeholders, especially at two extremely high-profile seminars held in Sylhet and Chattogram. The European Union also provided valuable technical support. Following further examination and refinement at the Ministry of Law, I'm looking at Tanim Shaun here somewhere. There you are, blast from the past. Following further examination and refinement at the Ministry of Law, the Commercial Court Ordinance 2026 saw the light of day on New Year's Day 2026. That's the best New Year's gift I ever received in my entire life. One of the most progressive provisions of the commercial courts legislation relates, as we've already heard, to mandatory pre-institution mediation. Additionally, mediation is permitted at any stage before judgment, thereby fostering a settlement-oriented culture and reducing backlog. It is a truism that economic growth and investor confidence rely heavily on contract enforcement and rapid dispute resolution. To this end, we have actively worked up towards establishing dedicated commercial courts equipped with specially trained judges and expedited procedures. The enactment of the Commercial Court legislation, that is now the Commercial Court Act of 2026, therefore stands as a benchmark achievement offering specialized tribunals and technology-driven processes designed to deliver swift, predictable, transparent, and market-responsive outcomes. ADR, esteemed guests, ladies and gentlemen, is not a marginal concern or a mere procedural alternative. It is the very bridge between the formal justice system and the people's lived reality. For far too long, our legal landscape has been dominated by prolonged adversarial litigation that treats every dispute as a zero-sum battle. By deliberately shifting towards consensual dispute resolution, we foster now a settlement-oriented culture that significantly relieves the pressure on our overextended courts. In that regard, we have championed decisive legislative shifts to embed ADR into the core of our justice delivery framework, a prime example being the amendment to the Legal Aid Act, which now mandates pre-case compulsory mediation. We must appreciate, too, that this is a collective enterprise. The legislature must enact, the executive must resource, and the bar must adapt. Bring that to alignment with also the need of our development partners, who must support with both expertise and, where possible, financial assistance. The desired outcome is a streamlined, commercially responsive, multi-pronged dispute resolution system. In this regard, throughout my tenure as the Chief Justice of Bangladesh, I acted on the belief that institutional and systemic progress is most effectively realized when supported by a community of legal, developmental, and other partners at home and abroad. Strategic partners like the United Nations Development Programme, UNDP, thank you for attending today, have been indispensable catalysts accompanying us on every step of our nationwide roadshows over 1.5 years. Similarly, the European Union, the United Kingdom, Sweden, Norway, Canada, Australia, and Japan, to name a few, have provided consistent and principled support, formally endorsing our agenda and providing a lifeline of comparative wisdom. Furthermore, a reforming judiciary requires a transforming bar. We have leaders of the bar here. Good to see you here, Dr. Bhuiyan. I haven't seen you in 8 months. Yeah. Thank you, thank you. The pleasure is all mine to see you here. So a transforming bar, Dr. Bhuiyan. Otherwise, the justice system moves asymmetrically. Judicial reform cannot exist in a vacuum, nor can structural changes at the bench, which we attempted to do. And we're still in the midst of a transition. I'm an optimist. So structural changes at the bench cannot succeed if the legal profession remains anchored to traditional inertia. The bar and the bench are two interdependent pillars supporting the same edifice of justice. If one advances while the other remains stationary, the entire framework suffers from structural imbalance. To achieve a truly equitable legal order, I call upon the business community, prominent lawyers, and our international development partners to remain equal, proactive, not reactive, proactive stakeholders in this transformative endeavor. I firmly believe that justice is not a destination, but a discipline. Let us ensure that our legal architecture aligns with our economic aspirations. Let it be said that we chose on this 15th anniversary celebration of BEAC to cross the bridge between legal promise and economic reality together, ensuring that justice is not a dream deferred, but a lived reality for every citizen and entrepreneur in Bangladesh. Thank you ever so much.
Thank you, my lord, for your invaluable guidance and inspiring remarks. May I please request the BEAC chairman, Mr. Mahbubur Rahman, to present the memento to our